Good morning. Uh, the judgment which I am going to refer and discuss with you will help to understand the provisions for granting disability pensions for the armed personnel and the ratio given settled in this Supreme Court judgment will be applicable to labor cases, Workmen Compensation Act and Factories Act, wherever the employee sustain some health problem, invalidated pension, health problem, resulting is removal or termination or whatever his services be put an end. There you can very well apply this judgment. Apart from that, if you go through the entirety of judgment, I would like to say a few words or share with you that nowadays I saw multi number of young lawyers are very muscle maintaining their body health. Then after some few years of service, probably I think 5 years of service, you can apply for junior commissioned officer in any military services. So there will be initially you will be engaged before departmental inquiries. Thereafter you will be sent to Armed Forces Tribunal. Then you may be appointed as a court martial. You can very well act as a judge also. Such a promotional avenues are there. Therefore, kindly go through this judgment. This is AR 2025 Supreme Court 2130. AR 2020 Supreme Court 2130. Bhuinder Singh versus Union of India. The case was simple. See, when he joined the service, his health was very good. Thereafter, what had happened, he was posted at high altitude, Siachen as Kashmir. So subsequently, he sustained some medical disadvantage. Then therefore, his services was terminated. So he claims disability element of disability pension, and the several board, reversal board, claims that he did not have more than 20% disability. Therefore, he filed an application before tribunal under section 14 of the tribunal, Armed Forces Tribunal. There what had happened, that was rejected. The review application filed, that was also rejected. Then automatically Supreme Court appeal. He filed an appeal before this honorable court under section 30 of the Armed Forces Tribunal Act. So several regulations act were discussed, provisions were discussed, how medical treatments are being conducted. Like that in labor cases also, or if you are working in your factories, or if any transport department, you are forced to work for hours together without giving some relief, alternative relief. If you sustain any injury or your health became deteriorated, this case would apply. So this judgment would apply because the ratio was very simple. When he was medically fit and selected. Subsequently, the disablement deducted by the medical board must be due to the service, due to the aggravated military service. This is what there is. Then you can also say that if any person is permitted to work more than the prescribed hours, and he sustains some healthy problem by inhaling dust or some powders, whatever it may be, all these things. Here is one more clue was given that when after joining military service, his life was also ensured, considering that he is medically fit. All these things are there. Kindly go through this. And young lawyers, you must read this judgment and go through the entire provisions and be preferred for junior commissioned officers being called for examinations. And if you are selected, you will be sent for a few months training, military training, and you don't afraid that you will be posted at a sensitive post. No, you will be posted at headquarters. Best wishes.